Oh, the carefree life on a cruise ship. If you've never been on a cruise before, you may not know what you're missing. It's quite the experience. I've been on several cruises. My wife really likes to cruise, and I think it's a good way to have a good vacation where you basically take your hotel wherever you want to go. Uh, you get to see the sun, the sand, the surf, really good food, tiny little cabin, third degree burns. Oh, wait a minute. Did I just say third degree burns? Well, that could be because I'm talking about a case out of one of the Florida appellate courts dealing with Royal Caribbean. Lest I forget, Tony DeWitt here, Missouri appellate attorney, a guy who likes to make sense of the law on YouTube, which isn't always possible, but I think it's pretty possible in this case. This case is a very good example of a courts interpreting a contract based on exactly what the contract says, as opposed to what the defendant wants the contract to say. So, many of you may remember several years ago when there was an eruption on a volcano down in New Zealand. Well, particularly since the seasons are reversed in the southern hemisphere, our winter up here is their summer down there, and it's a wonderful time to go cruising if you don't mind the 13, 14, 15-hour flight to Australia to get there. And there were several people who did take that flight from the United States, as well as people in Australia who decided that they would go on a cruise that took them by the volcano in New Zealand. Now, volcanoes are nasty critters. They, have temperatures that probably come as close to Hades as possible. And molten rock, if you have ever been to Hawaii and walked on the lava out on the Big Island, even lava that's been hardened for 2 years, you could still cook a steak on it. And you best walk in really good shoes and not spend a lot of time with a rubber sole in contact with that lava field. But be that as it may, because they do produce a great amount of heat, they are not something to be trifled with. And that's what this case is really all about. It's about the volcano and, to a certain extent, the reasonableness of the precautions that Royal Caribbean took in marketing a shore excursion to an island that had a volcano. So let's take a look at the text of the opinion, and then I will come back and offer you some thoughts. This is an appeal from the 3rd District Court of Appeals in Florida, deals with the Miami area. It's an appeal from a non-final order from the Circuit Court of Miami-Dade County. And there are a number of high-powered attorneys litigating this. And the panel is Emas, Miller, and Bokor, and Emas wrote the opinion. Ian Hui Oi, an Australian citizen, filed a negligence action in Miami against Royal Caribbean Cruises Limited, Royal Caribbean, alleging that while a passenger on a Royal Caribbean cruise, she sustained injuries during a shore excursion to a volcano in New Zealand. Royal Caribbean moved to dismiss the action on several grounds, most of which was improper venue based on a forum selection clause in the passenger ticket contract between OI and RCL Cruises Limited, RCL, which is a separate but related entity in the United Kingdom. And in case any of you don't remember what a forum selection clause is, basically it is part of the contract that you enter into when you take a cruise that says if somebody gets hurt or somebody gets injured in some way and it has to be litigated in a court of law, we both agree that we're going to go to this particular court. And of course, a lot of the cruise lines now have requirements for arbitration. Arbitration is an absolute disaster and not something that I would recommend to any client. And I try very hard never to sign an arbitration agreement. But that's what this forum selection clause is at issue here. It basically specifies where claims are supposed to be brought, but it doesn't say what Royal Caribbean thinks it says. Royal Caribbean contends, among other things, that the trial court failed to hold an evidentiary hearing and further erred in failing to make an express finding that the forum selection clause does not apply, or an express finding that enforcement of the clause would be unreasonable or unjust. We find no error in the trial court's order and affirm. So then they go into the factual background. They were sailing on the Ovation of the Seas, which is an RCL ship, United Kingdom entity, and it's separate from defendant Royal Caribbean. During the cruise, OI participated in a shore excursion to White Island volcano in New Zealand, and that's where the one that erupted. Royal Caribbean approved the promotion and sale of the excursion, and she also alleges that all of her arrangements for the excursion were made through Royal Caribbean. During the excursion, the volcano erupted and OI sustained severe burns. The disaster resulted in numerous lawsuits, many of them filed in Miami and some in Australia. The passenger lawsuits maintained generally that the eruption was foreseeable because weeks before the accident, the volcano showed signs that an eruption was likely to occur, and a volcanic alert level was increased to the highest level possible without an actual eruption. Star note, if that is ever the case, you absolutely do not want to go on that shore excursion. Significant to this appeal, the passenger ticket contract between OI and RCL includes a forum selection clause. We both agree that any dispute or claim will be dealt with by a court located in New South Wales, Australia, to the exclusion of any other state, territory, or country. In December of 2020, approximately 1 year after the incident, Royal Caribbean, and that's different now from RCL, initiated proceedings in the Federal Court of Australia seeking 1. A declaration that any disputes between Australian passengers would be subject to the exclusive jurisdiction of New South Wales, and 2. An anti-suit injunction restraining Australian passengers from pursuing a lawsuit against Royal Caribbean in Florida. So the Australian court conducted a multi-day evidentiary hearing on the matter at which Royal Caribbean presented evidence to support its motion. Following that, the court held that Royal Caribbean was not a party to the Australian passenger ticket contract. The passenger ticket contract was limited to RCL and Australian passengers. The forum selection clause in the Australian passenger ticket contract did not extend to Royal Caribbean, so it rejected the injunction. And it says, while the foreign judgment was not filed below, the affidavits submitted by Royal Caribbean in support of its motion to dismiss, as well as their briefs on appeal, do not contest the accuracy of these representations. So in 2022, January, OI filed this lawsuit in Miami, and Count 1 said that Royal Caribbean was collaterally estopped from arguing that Royal Caribbean in Miami was subject to this forum selection clause, and 2, that they were judicially estopped by virtue of the judgment of the Australian court. So, in spite of that, they filed a motion, omnibus motion, to dismiss plaintiff's complaint as a sham pleading and to dismiss with prejudice for improper venue and for failure to state a claim. So the motion sought dismissal for improper venue based on the forum selection clause. Ultimately, the trial court denied the motion without an evidentiary hearing, and this appeal followed. So the standard of review, and again, that's the most important thing when you're looking at an appeal, to look at how the court is going to review the issues in the case. And so the interpretation of the contract, which is a legal ruling, that is determined de novo, meaning the appeals court looks at it as if the trial court never made a determination. And they also apply a de novo review to a motion to dismiss, and they accept as true all well-pled and unrefuted allegations of the complaint. So then they drift off into analysis and discussion, and they say, the right to select venue belongs to the plaintiff, and it's defendant's burden to plead and prove that venue is improper. However, where relevant parties executed an agreement with a forum selection clause, such clause is presumed valid, and the party seeking to avoid its application bears the burden to establish that trial in the contractual forum will be so gravely difficult and inconvenient that he or she will, for all practical purposes, be deprived of their day in court. A plain reading of the passenger ticket contract supports the trial court's order denying Royal Caribbean's motion to dismiss for improper venue. The passenger ticket contract was not between OI and Royal Caribbean, but rather was between OI and RCL, a separate entity. The forum selection clause provides, "We both agree that any dispute or claim will be dealt with by a court located in New South Wales, to the exclusion of any state, territory, or country." The plain language establishes that the forum selection clause applied to the signatories, RCL and OI, and did not extend to Royal Caribbean. In addition, Royal Caribbean was not entitled to an evidentiary hearing where the affidavits it submitted failed to place a relevant fact in dispute. Where a defendant's motion to dismiss based on improper venue raises a disputed issue of fact, such an issue must generally be resolved in an evidentiary hearing. However, no evidentiary hearing is required if the affidavits don't create a factual dispute or if the factual dispute is not relevant to the question to be decided by the trial court. And of course here, the question to be decided by the trial court was, what did the forum selection clause say and who did it apply to? So they say the complaint in this case specifically described the Australian proceedings and the alleged application of collateral estoppel and res judicata because the Australian court, at Royal Caribbean's request, held that Royal Caribbean was not a party to the contract and thus the forum selection clause did not extend to claims filed against it. And Royal Caribbean's affidavits don't refute the allegations. Furthermore, the construction of an unambiguous provision in a contract is a question of law for determination by the court. The trial court's purely legal determination that the forum selection clause by its plain and unambiguous terms applied only to RCL and OI did not extend to Royal Caribbean. In fact, the affidavits filed by Royal Caribbean were offered in support of a separate and distinct basis for which it sought dismissal, that Royal Caribbean was not a proper party to the lawsuit filed by OI because the passenger ticket contract obligated only RCL and not Royal Caribbean. Now, here we go down to section 2, or the footnote 2, where it says we do not address whether Royal Caribbean, as opposed to RCL, is a proper party to the negligence claim filed by OI. And the reason the appellate court doesn't address that issue is because it's not before the appellate court. That is not part of what the Royal Caribbean appealed in this appeal. And it hasn't likely been determined by the trial court yet, so it couldn't be a part of this appeal. And as the footnote makes out later on, there are all kinds of issues with regard to privity of parties and that sort of thing, and privity in contract, which basically privity just means a relationship exists. All of those things also affect whether or not there could be collateral estoppel and judicial estoppel, and they're just not going to go there because they don't have to. The contract's reading, its plain and unambiguous terms, all support the judgment of the trial court here. Because Royal Caribbean's affidavits failed to present a disputed factual issue related to the trial court determination that the forum selection clause did not apply to the lawsuit filed by OI against Royal Caribbean, no evidentiary hearing was necessary. But again, where the facts related to such an issue are in dispute, you can hold an evidentiary hearing, but where there's no factual dispute, you don't need to hold a hearing. And they say, tellingly, nowhere in the 70 pages of appellate briefs filed by Royal Caribbean does it point to a specific relevant issue of fact that was placed in dispute and required the trial court to conduct an evidentiary hearing. Finally, a review of the record establishes that Royal Caribbean failed to raise below the argument it now makes on appeal that it could enforce the forum selection clause as a non-signatory, or relatedly, that an evidentiary hearing was necessary to determine whether the relationship between it and RCL was such that Royal Caribbean could enforce the forum selection clause as a non-signatory. Quite to the contrary, Royal Caribbean continued in its omnibus motion to dismiss that it was not a proper party to the lawsuit filed by OI, because Royal Caribbean failed to argue to the trial court that it could enforce the tickets contract's forum selection clause as a non-signatory, or that an evidentiary hearing was necessary to resolve that fact. The claim was not properly preserved and can't be raised for the first time on appeal. As a result, we hold the trial court to failure to conduct the evidentiary hearing was not erroneous, and the judgment of the trial court is affirmed. So it's going to be remanded back to the trial court for continuation of the case. Now, you might be inclined to think that this means that the plaintiffs are going to prevail in this case, and I don't know that that's the case. Royal Caribbean had a limited role in setting up these shore excursions. That's often the way corporations that are sort of organized into different business units operate. RCL takes the cruise passengers, enters into a contract with the cruise passengers, but then when they go to book shore excursions, they go through Royal Caribbean International, the US-based corporation, and that's where they make those arrangements. Well, now you essentially have to allege and prove knowledge that Royal Caribbean in the United States knew that volcano was at risk, and I don't know that they'll have that opportunity. They very well might get thrown out at summary judgment. It's hard to tell. But what's interesting here is the idea that you can sort of take this appeal or take an appeal in pieces. Most states don't allow motions like a denial of a motion to dismiss or the denial of a motion to dismiss for improper venue to be appealed immediately. Usually they say, well, if you want to appeal that, you have to wait till the end of the case and get a final judgment. That's certainly the case in Missouri. In Missouri, you could ask for what's called an interlocutory appeal, but it'd be very rare when you got it. And it would have to be a fairly significant issue, something that was really case dispositive, before I think an appeals court would actually take those issues up. And of course, the trial court would have to approve that in an order saying that there was no just reason for delay of the appeal, and for that reason, yes, Court of Appeals or Supreme Court, please take this issue up and make a decision for us. I don't think it's a good idea to have this. I think Florida law is kind of messed up in that regard. But in some respects, it actually, particularly in this case, it's going to help the plaintiff, because now this is called law of the case. So if at some point in time the the defendant here, RCI, decides that it wants to make a claim on appeal that the Court of Appeals got this wrong, if they don't try to take this up to the Supreme Court now, then it will be the law of the case, and they won't have an opportunity to have that issue relitigated at a future point in time. I think the Court of Appeals did everybody a service by analyzing this issue at the time that they did. Now let's have a little kindness moment here. One of the things that you can do that is a kindness that, again, only you can do, is to volunteer. Now, a lot of companies will actually pay you your regular wage to go out and volunteer. Not all of them, but many of them do. And there are a lot of different places that you can volunteer. A lot of times you can volunteer at the library. A lot of the time you can volunteer at your local hospital. Particularly if you're in a small town and you have a small 100-bed hospital, a lot of times volunteers play very important roles. They take menus to the patients to help them choose food. They may wind up transporting patients in wheelchairs from their patient room down to X-ray or cardiology or some other place. There are lots of roles that volunteers can play in healthcare, and I would seriously urge you to consider volunteering at your local hospital. It is a great way to serve people, and it's a great way to pass on kindness. And if you've ever been a patient in a hospital, you probably have a volunteer to thank for why your bill was not higher. So think about that. Have a marvelous day. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.